property at 1301 Eden Drive, which is the Eden Care Facility. Basically, I think what we're wanting to determine is the status of the lien claimed by Mooring Recovery Services. We have, of course, Mr. Terry Jackson representing the city, Mr. Bruce Smith representing the Seven Landlords joint venture. I'll give just a little brief history, which I think most of us know. The hearing initially was held August 9th of 2016, when the order of demolition was entered by the court, and then about a month later, on September 7th, 2016, the order was amended to give Seven Landlords joint venture until December 31 to determine whether to demolish or rehabilitate the facility, which would then give any lien holder 60 days after that date to exercise any rights to that. That then was extended a little bit further, I think, so that there was a potential buyer that was going to buy the property, and I understand that has not come to fruition. So we decided to have this hearing today to invite the lien holder, which we've learned is Mooring Recovery Services, to attend and find out what their position is on their claimed lien against the property. It's my understanding, proper notice has been sent to Mooring Recovery Services. I don't know if there's anyone here today. Are there any folks in the audience here that have an interest with Mooring Recovery Services? Apparently not. These folks were advised, or their attorney was advised by Mr. Terry Jackson, as well as by a certified letter sent by the court, which they've acknowledged receiving, and they've acknowledged knowing of the hearing today, but apparently no one is here on behalf of the claimed lien holder. So, Mr. Jackson, I'd like to start with you. What do you know concerning our lien holder? Let's kind of proceed with that, what their status is.
Yes, Your Honor, if I may. Initially, the lien was not found by the city. Mr. Smith has been very good about keeping us apprised of anything that's happening with his client or anything in this case, communicating with us. He's been very good about that. On December the 21st, when we found out about Mooring through Mr. Smith, Bruce Smith, we then determined that Mooring Recovery Services Incorporated, because of their lien, needed to be communicated with. We were about to enter that 60-day period where lien holders had the opportunity, or have the opportunity, to take advantage of an opportunity to demolish or repair, to do the things. If the owner of the property has not, at that time, they have the opportunity to do so because of their lien. We did notify them, as the court said. Sally Forbes, the court's clerk, had notified them. Mooring Recovery Services Incorporated on the 24th of January 2017. Subsequently, this office, and again thanks to Mr. Smith, was able to directly, on February the 2nd, directly contact Jeremy Sanders. Jeremy Sanders is a Houston attorney. He is counsel for Mooring Recovery Services Incorporated. At that time, I spoke to him on the phone and was confident that he was aware of the case, what was going on with the case, and that we were in had entered that 60-day period where his client could exercise its rights to repair or demolish the structure. He seemed to indicate that they weren't interested in repairing or demolishing the structure, but they weren't interested in releasing their lien in toto. So what I did at that time is said, hey, let me send you something, and you look at it to see if you might be interested in signing this to just simply release your claim to the structure and the structure, building or structure only, on the property at 1301 Eden Drive. I have what I'll mark as cities number 1 for the purposes of this hearing, is a document, and would certainly be happy to make that available, a copy of it, to Mr. Smith, and it would, the court accepts it into the record. It will be in the court's record if we could make a copy from that record for anyone. But this is cities number 1, Your Honor, and it is the something of a release of lien there, but only as to the structure there at 1301 Eden Drive. In response to that, I received an email, and I sent that by email to Mr. Sanders, and in response to that, I received an email back from Mr. Sanders, and Mr. Sanders' email said, we understand that the building on the property in question has been ordered for demolition, and we do not object as to the lawfulness of the order for demolition. However, my client, Mooring Recovery Services Incorporated, will not be releasing any lien or lien rights it holds relating to 7 landlords and our Crest Care, aka Eden Specialty Care, regarding the property in question, fee interest, and leasehold interest, that being in parentheses, fee interest and leasehold interest. I will mark that as cities number 2. And we would offer that.
We don't have objections to 1 or 2.
Well, I'll admit into the record cities exhibits 1 and 2.
Your Honor, then finally, as to number 3, cities number 3, was my response back to Mr. Sanders, which said, thanks for speaking with me recently and your emails regarding Eden Specialty Care /7 landlords. I just want to remind you that the hearing regarding the Eden Specialty Care 7 landlord structure is this Thursday, February the 9th, 2017 at 1 p.m. in the city of Longview Municipal Court at 302 West Cotton Street in Longview, Texas. Thank you, signed Terry Jackson. Oh, there's no objections.
All right, exhibit 3 is admitted.
Your Honor, I've had no further contact with Mr. Sanders after that. Since he was actually served, he and Mooring have been made aware of the representative of Mooring and Mr. Sanders have been made aware of this. Actually, notice has gone to the company and to, I believe, and to Mr. Sanders. They've been made aware of this hearing. They've been sent emails, and we've spoken with them personally on the phone. They have chosen not to be here today, it appears, so we assume that they are not exercising their right. They have the remainder of 60 days from December 31st, 2016 to exercise any of those rights as to demolition or repair. But from my conversations with Mr. Sanders I don't anticipate that that's something that they are going to do at this point in time. Your Honor, that basically is the information that we have and the steps that we've taken to help address the lien that Mooring Recovery Services Incorporated has on the property. If the court has any questions, or Mr. Smith, we'd be glad to try to answer those.
Mr. Smith, do you have any information or comments that you might could add that would be helpful?
Your Honor, not to waste your time, if I could give just a little bit of background. I agree with everything that Mr. Jackson just said. He did not recite anything incorrectly. Going back, what originally happened is Mooring Recovery filed a lien against two entities, 7 landlords, who's the actual owner of the physical structure, and Eden Specialty Care. They're just a tenant. Not really much thought went into any of that at the time. As we were in that period where we thought we had a buyer, and by the way, that gentleman, it's not a fictitious person. That person actually met with representatives of the city, explained what he was going to try to do with the property. They couldn't get on the same page, and that guy's no longer a prospect. So, but as that was kind of happening, I said to myself, wait, we wouldn't be able to sell this building if there's a lien on it. And I want to make sure that this is all on the record. 7 landlords does not in any way acknowledge that is a valid lien. 7 landlords has had no communications with Mooring, entered into no agreements with Mooring, didn't hire or promise to do them anything. And we have specifically asked Mooring to release that lien as to 7 landlords because they have absolutely no lien rights against us, which they have refused to do. They are in the middle of a lawsuit right now, filed here in town, where they're seeking $581,000 for work that they say they did out there. So anyhow, in the course of trying to get that all released, Mr. Jackson and I were talking, and I said, did Mooring ever get notice initially for that August 9th hearing? And it appears as though it did not. Notices were published in the paper and those kind of things. My client is now to the point of understanding that we've got to move forward with demolition. And we're actually talking to a gentleman right now who would do all of that for us, give us a bid for all that. The only thing that we want to make sure is that we don't make our circumstances even worse by taking down a building that a lien holder says, well, wait, we didn't get notice, we would have done something with that building. And now our rights have been harmed in some way. So all we want to make sure is that, and I've heard it, I've seen it, something from this court that says lien holder waive its rights or agrees or whatever, so that we know that as we move forward to demolish this place, we're not creating more liability for ourselves. And I've asked him to release that lien. I'm repeating myself. I've asked and I've gotten nowhere.
Thank you. Thank you, Mr. Smith. Well, it certainly appears that Mooring Recovery Services had actual knowledge of this here today. And I'm looking here at City's Exhibit 2, where we see the statement by Mr. Jeremy Sanders. Quote, "We understand that the building on the property in question has been ordered for demolition, and we do not object as to the lawfulness of the order for demolition." End quote. So it sounds like he is acknowledging on behalf of Mooring Recovery Services that, hey, we are aware of the order, and we do not object to the lawfulness of the order for demolition. I don't know if that's artfully selected words. I don't know really what that means, but it sounds like he concedes that the order is lawful, and then subsequently, as Mr. Jackson's pointed out, as the exhibits show, he was, or Mr. Sanders, as counsel for Mooring, was advised at the hearing today and, simply, I guess, decided not to come and has not really corresponded or notified anybody as to why. They still have, a few days, 60 days from December 31st, which would be roughly March 2nd or 3rd, I suppose. I haven't counted, but they have 60 days from December 31 to do something with the building. And obviously, I don't think they're going to. So then that puts us in the situation, I know we have a hearing scheduled for March 7th, but puts us in the situation that at that hearing, that would be after the 60 days that the lien holder has to do anything, and they haven't done it. I noticed you were going to say something maybe that you could be of some help.
Well, I think you're right. I don't think Mooring has any intent to do anything with that building. Again, our point is just to make sure we don't make it worse for ourselves than we already have. Here's my only question, and I don't know this answer. If the ordinances here require that a lien holder get notice of the original hearing to declare it to be a substandard dangerous building, which they didn't get, I'm assuming that's why this one went out for March the 7th. That hearing is not necessary for my client, obviously. We've been down that road. Do we need to have that hearing just to protect the city and my client so that we know that proper notice went out and those kind of things? That's the only question I think this court, we all need to kind of get our arms around.
Well, I agree. Are you suggesting, and maybe Mr. Jackson, you might have some thoughts on this, that that another notice of hearing to determine whether or not this property is substandard and needs to be either demolished or repaired, that should be going to Mooring Recovery Services through their counsel, Jeremy Sanders, so that they may appear March 7th on that issue?
To me, the most logical thing, and that email comes pretty close to it, the most logical thing is for Mooring to say, we have no objections, move forward, signed it, I mean, an official kind of a document, if you will, versus just an email. And I think we're all okay. That if there's somehow, and Terry tried to get there with, I guess, a partial release, if you will, and we just have something signed in writing to this court that says, you know, that email, but it's signed by the lawyer on behalf of his client, maybe we're there. I'm not trying to create any more issues than are necessary, because I'm gonna continue to work with this gentleman to demolish this building and get the quotes and those kind of things.
Well, that's what, of course, the court has entered the order, and that's my interest too, is we want to get something done with this building, don't want to put it off. I think it needs to be resolved. Mr. Jackson, you think that, you know, that's certainly a good idea. Now, if he puts this in the form of an email, it's pretty close to saying, I agree, you can go ahead and demolish the building. I still have my lien as to the real property, I suppose. But I'd like to see us do something like this, so that at this hearing on March 7th, we're ready. And I would like, of course, I think you're correct, Mr. Smith, that you're ready to move forward with the demolition, if you can.
And one of the things that I would like for whatever he signs is to say he acknowledges that he received proper notices from the city of Longview regarding the dangerous condition of the bill, or whatever it is. Because I don't want him to come back later after the fact and say, well, honestly, you didn't give us notice the first time this went around, and now you really have stepped in.
Mr. Jackson? What
Your
are your
Honor,
thoughts, sir?
we could certainly, no, I do think there's provisions, in case a lien is missed, in case they're not found somehow, some interest is not found. And we have taken the opportunity to do those things, the publication, of the notice, publication of the hearing, all of those things, we've done. And we sent an order to Mooring Recovery Services Incorporated. However, we do not object at all to giving them, official and proper notice. We can ask, Ms. Forbes, and she will do that as to the hearing on March the 7th, I believe we said it was, as to the hearing, and she will give notice to Mooring Recovery Services. We will also ask Development Services to also, send notice as to, official notice, certified and uncertified, and kind of nail them down on this. And then we believe if they're not there, I don't know, I can't speak for Mr. Sanders, I can certainly send something to him, don't mind that at all. I don't know what he's going to do, this was all he would do. He completely rejected, the document that I prepared that clearly stated this is only a release as to a building or structure on the property, and in a partial release of lien, and in no wise otherwise releases any lien. But apparently that wasn't sufficient, or he didn't think that was something that his client could enter into, so he did just send the email. I can certainly send him another email, and I can attach another release form, basically stating what you and Mr. Smith have shown as your interest in here, see if that will happen. But if it doesn't, we will also be giving him notice, or at any rate, we will be giving him notice as to the March 7th hearing, and I think at that time, if they choose not to appear, if they ignore that, I believe they have obtained sufficient notice, and I believe any interest is extinguished at that point with the argument.
Yes, sir, Mr. Smith.
I'm happy to work with Mr. Jackson, to try to get the wording right, if he would sign a letter, kind of mistake on it. I think the problem is, Mooring is very nervous about signing anything that would somehow lead to an appearance that they're giving up their lien rights. They look at those as being very valuable in the existing litigation. And short of doing this correctly, giving them all the proper notices, I think we're going to struggle to get the wording accurate. Here's my only question, because I'm not trying to delay this. This happens on the 7th. The court says, I enter an order that this is considered to be a dangerous building. You have 30 days, whatever the statute says you have to demolish, repair, whatever. And as I understand it, within these 30 days, and there's 60 days that says a lien holder has the right to come here and do something. So that's going to be 90 days from March the 17th, theoretically before we could even get started, without potentially violating lien holder's rights.
Why would they have an additional 60 days? If they are the lien holder, then wouldn't they have just 30 days?
Now, correct me if I'm wrong, as I understood it, at the end of the orders period, there's still 60 more days for the lien holder, not wrong about that.
Well, this has been an unusual order. Typically on the order, the court would grant 30 days to the property owner, and then an additional 30 days by statute in ordinance to the lien holder. So if there were a brand new order that was entered, then that would get a total of 60 days. If it were what we standard.
Then we would be talking 60 days from March the 7th. Again, I'm going to tell this court, I know Ms. Ishihara, I hope I say that right. I know she's very concerned about this. This isn't going to slow me down what I am doing already. Because we know where we got to end up. Just don't want it to, I'm repeating myself now, I don't wanna create more of a situation than we already have.
Well, I understand that, and I'm sort of like Ms. Ishihara. If we can keep this moving, because the court did enter the order, and I understand your concerns. Certainly, if Mooring has filed $581,000 lawsuit here in the Gregg County, apparently, and I'm sure they're not at all interested in giving up their claimed rights. And I can understand the position of your client saying, we don't view your lien as really being what you think it is. But if this would not slow it down, because I gather in the meantime, you would be working with folks on asbestos abatement or things of that nature, am I correct?
So the individual that I'm visiting with is an all-encompassing, which would include, I mean, he does it all.
Does it all.
Or hires it out to do it all, but it would start with asbestos abatement, get all that, get the certificates done, and then begin to actually demolish the building. Gotta start with the asbestos abatement. But we just would be hiring one person to do the entire job.
Would you begin doing some of this within the 60 days from March 7th?
We've got to.
Or do you jeopardize your client's rights if you do so?
Oh. My belief, Your Honor, I've had conversations with an individual, local person to do this, and they've also been talking to my client at the same time. And what we're trying to do is get an estimate from this gentleman, so we know what we're dealing with. Because if he says, you know, it's $3 million to tear this building down, we're gonna go find somebody else to go demolish this building. So that's where we are right now, trying to get him information so that he can make an estimate to us of what it would cost to demolish the building, asbestos abatement and all. Maybe I've just said that if we just let this run its course, and I continue to do what I'm doing, maybe that's just the best thing, that you enter an order on March the 7th, and 60 days, 30 days after that, everything's done. I mean, we're hopefully working to pushing the thing over by then.
Could that be done, Mr. Jackson? If we could do so, and maybe you and Mr. Smith could draft this, the letter or the document that would be going to Mooring Recovery Services. It's the interest of the court, you know, of course, we know, I think it's established by now that the structures will have to be demolished. And it sounds like Mr. Smith's client is prepared to do so, and I gather that this is being worked out or has been worked out with your insurance carrier. Am I correct there?
To say that anything has been worked out with the insurance carrier would be wrong.
No.
I can't say that, and I think that'll become more apparent soon enough.
Okay. Well, let's do that then. We will notify, and we'll take, Sally, I suppose we're starting here. Notify Mooring Recovery Services and their attorney, Mr. Jeremy Sanders, at the hearing again on March the 7th. And that at that time we will, to determine whether or not this is a substandard building, which would be essentially what has already been determined, and whether it should be demolished or repaired. And then they have the opportunity to appear, and I would assume they would appear at that hearing. If they don't, then obviously they've given up any rights, but I'm a little surprised that they didn't elect to appear today, frankly, but maybe they've got their reasons. And I suspect it's tied in with their $581,000 lawsuit that they're filing here in Gregg County. But let's do that because we want to keep this moving forward. And I guess the sticky point at this point is still Mooring Recovery Services, but we want to get them or get their interests taken care of as quickly as we can. Any other questions, Mr. Jackson, or comments?
May I have just one moment?
Yes, please.
No questions from the city or anything.
Okay, Mr. Smith, any other?
I have nothing further, Your Honor.
All right, then, we'll proceed with the notification to Mooring Recovery Services and to, all of the parties of, this hearing on March the 7th, and, proceed, with it at that time.
Thank you, Your Honor.
All right. The hearing is adjourned.